President Trump asked the U.S. Supreme Court to weigh in on a specific part of the document review when it comes to the special master's review of the documents taken from Mar-a-Lago. And it's specifically the classified documents. The Department of Justice has said, hey, we don't want the special master to have to be able to review those. We want to continue our criminal investigation. The 11th Circuit said the special master does not get these documents, that the DOJ can keep them, continue their investigation. What President Trump is saying here is, listen, some of those documents, out of the 10,000, we're talking about, we think about 100 pages of paper here. It could be classified or marked classified. We don't know if it's remained classified because they could have been declassified. But there are documents that can be both marked classified and be privileged. And those documents should be excluded from the DOJ's investigation.
They are saying this is not a final disposition. This is just interlocutory, which means interim only, and that you cannot appeal it. That's number one that they're saying. So that the Supreme Court should say, 11th Circuit, you stay out of this. You let Judge Cannon handle this. Judge Cannon appointed this special master. Let the special master do what the judge has told him to do.
Other part of this question too, Andy, which is, did the circuit court really have the jurisdiction to override what the trial court judge is trying to, how she's trying to conduct her trial?
The 11th Circuit, I think, jumped the gun on this and got into an area that it should not have injected itself in, and that is the discretion of a district judge to appoint a special master with instructions to that special master to report to the district judge. And therefore, that's one reason why I think this case isn't over. Therefore, an appeal that the Justice Department took to the 11th Circuit was premature, and that's one of the things that the Trump lawyers have pointed out.
When it's the former President of the United States, Andy, they do, I think, take at least a second look, even if their initial reaction is, I don't want to get involved in this, the trial decisions that, but when it's a former president, I think that there's a lot of pressure on them, both sides of their ideological spectrum, to clear it up for everybody.
With a president, or in this case, a former president, I think they look at it more critically and with a view possibly toward that. We don't know whether they're going to take it or not, but if I was betting, I would say that they probably are going to look into this because of the depth of privileges and things that are implicated.
When it comes to presidential or former president's privilege, that does add some weight. And it's kind of why they exist. The U.S. Supreme Court is when you got these different, branches of government, and a former kind of branch, but exerting executive privilege, and then another branch of government, or another government agency saying, hey, we should be able to get these documents, like Nixon tapes, like Paul and Jones, but it's not at that level. I would say it's not nearly at that level, but it is could be a very interesting precedent that could be set